Your Honor, may I just say what my interpretation of the law is concerned. I believe that
You're referring to the CGTA law.
yes, Your Honor, that it applies to all, regardless of the kind of crimes they have been convicted. Because under the law,
What particular plea
section
applies?
one, the one amending section 29, it only amends
The
the
theory of the
provision on
Secretary.
preventive imprisonment,
Yes.
but nothing is said about the non-qualification of the other convicts.
Yes. All right. I maintain a contrary view, Mr. Secretary, and just for discussion. You are saying, just to clarify, you are saying that a heinous crime convict would be entitled to good conduct time allowance.
Yes, Your Honor.
Now, the contrary interpretation, and this is how the interpretation of the Secretary of Labor, is that they are excluded from the benefit of the good conduct time allowance law. Now, I'm just stating first the premises. Now, your interpretation that they are included is because when you compute the time allowance under Section 3, it doesn't exclude anybody. Is that what you're saying? That's the basis.
That's right only. That's right, Your Honor. It
Now-
only refers to the preventive imprisonment.
That's correct. Except that if you recall Section 1 on preventive imprisonment, it excludes from crediting those who are guilty of heinous crimes. And let me invite your attention. The law uses the word charge. In other words, if you are charged with a heinous crime, you cannot claim credit for your preventive imprisonment. That's under the law. It's clear. Di ba?
I don't think so, Your Honor.
No, yes.
Because what is only prohibited there is your being credited in Section 1 about the preventive imprisonment.
Yes, I agree with you. That's what I'm saying. Under Section 1 of the law, it is beyond debate that if you are being charged with a heinous crime, your period of as a detention prisoner cannot be deducted from your final judgment. That's clear under Section 1, di ba? Yes.
It's only the expanded GCTA that will not be deducted. But you should be credited the GTCA under the revised penal code.
But did the revised penal code credit you for preventive imprisonment? I don't recall.
No, in the revised penal code, there's also credit for GTCA, but in a reduced.
Anyway, the theory, and I think this is the basis of the Department of Justice, if those merely charged, underscore charged, with heinous crimes are excluded from the benefit of having their period of preventive imprisonment excluded, there is no rational nor justification for now allowing those convicted of heinous offenses to allow them to be credited and have the benefit of a good conduct time allowance. When in fact, if you are only charged, you are excluded from the benefit. With more reason, if you are convicted, you cannot avail of this benefit.
That's the problem with the law, Your Honor, because we are debating on this because the law is not clear. But even your interpretation could mean only that they will not be released even if they've already completed their sentence during the preventive imprisonment. It could only refer to that.
Yeah, they could not be released. They could not be released.
They
But
will not
the
be
principle is...
released because there is still a trial to be made.
Yes, but if the principle is that they could not be released while they were just charged, with more reason if they're already convicted, how can they be given the benefit? Anyway, the incumbent, our successor, the two of us, our successor is here, Secretary Guevarra. Maybe you can explain.
Yes, thank you, Senator. We have already explained this quite a number of times as to how we came to the conclusion that it was the intention of the law really to exclude these four classes of PDLs from the coverage of Republic Act number 10592. As a matter of fact, that very same section cited by former Secretary Vitaliano Aguirre contains a sentence, one sentence alone, that says, finally, provided finally, that recidivists, habitual delinquents, escapees, and persons charged with heinous crimes are excluded from the coverage of this act. This act.
This act, we agree, yes.
So I think that's literally clear to everyone, especially if we relate this to the other provisions.
So in your view, Secretary Guevarra, just on that portion, just that portion of the law, doesn't have to be amended. Because in your interpretation,
Yes.
heinous crimes convicts are excluded from the
Yes, sir. This is the
good
wording.
conduct time allowance.
Sorry, sir. Yes, that's the very wording of the law. It's just that maybe if it were placed separately in its own section, not inside or not contained within this section 1 pertaining to preventive imprisonment, maybe it could have been a lot clearer.
Okay.
Your Honor, I disagree because the Act does not refer to Republic Act number 10592. Act refers to Act number 3815, the Revised Penal Code. That's the Act being referred to because that's the Act being amended. It is not this Act, 10592. It is the Revised Penal Code, Act number 3815.
Well, if you look at the history of how this became, how this was enacted, originally the bill only referred to crediting of preventive imprisonment, not the CGTA for finally convicted. And that is why originally it used the word act, because the act referred to the law that would have allowed you or allowed the convict to avail of the benefits of their preventive imprisonment being deducted unless you are convicted or you are charged with heinous crimes, in which case you cannot avail of this benefit. That was how the law came when it got to the Senate. But the senators, very bright, they included Section 3, which now refers to
GCTA.
finally convicted prisoners. Kaya nagkagulo. But the intention really is to exclude those who are convicted of heinous crimes.
Your Honor,
Yes.
Section 1 reads, Article 29 of 38.1 of Act 3815, as amended, otherwise known as the Revised Penal Code, is hereby further amended to read as follows. So it is the Revised Penal Code, Act number 3815, which is being amended.
I'm
That's
sorry,
why
I
when
disagree with
The
that.
word act was being referred to in the last in the last paragraph. It refers to Act 3815, the Revised Penal Code.
May I say something, Mr. Senator? If that would be the correct interpretation, that would even make it worse for all of convicted persons. Because if we're saying that even under the Revised Penal Code, these people convicted, recidivists, escapees, etc., will be excluded from the benefits being added under this new law, then that will be applying retroactively to their disadvantage something that is being crafted in 2013. So that makes their position even worse